I'm Roberta Lynch, and you're watching Medfield.tv.
Access to our community.
Welcome to Simply Legal. I'm your host, Geraldine Warren, a longtime Medfield resident and practicing attorney here in Medfield. Last month, I started a series on bankruptcy, and we discussed Chapter 7 and Chapter 13. Today, I have with me David Madoff, a partner of Madoff & Curry, and he will be discussing Chapter 11 with us. So welcome, David.
Thanks for having me.
To begin with, do you want to just tell everyone a little bit about yourself and your firm?
Sure. Again, the firm is Madoff & Corey. We're located in Foxborough, a little down the street from the stadium. In fact, if you tailgate at the stadium, you can stop by. We tailgate there as well on the weekends. Our firm is, my partner does generally corporate work and real estate transactions. My practice focuses on bankruptcy. I am a Chapter 7 bankruptcy trustee. I know you talked about Chapter 7 in your last or the one before. We do Chapter 7s and 13s, but primarily I focus on doing Chapter 11 work, which is business reorganizations generally.
Now, do you want to just tell the community a little bit what's the difference between Chapter 7, 13, and 11, just so that they get an overview of the differences?
Sure. So as you learned, if you watched the prior shows, a Chapter 7 is a liquidation. And Chapter 7 is for a consumer, individual debtor, or it can be for a multi-billion-dollar company. If you liquidate, you generally do it through Chapter 7, although sometimes you can do a liquidation through Chapter 11, which we can talk about. A Chapter 13 is strictly for individuals. It's an individual reorganization plan, and it's an entirely different process than the Chapter 11 process. But it's a chance, again, as everyone learned, hopefully, it's a chance for individuals to get rid of mostly their consumer debt. Chapter 11 is an opportunity for a business, sometimes an individual, but generally a business, to reorganize their debt, hopefully save their business, and move on.
Now, when would a company maybe consider filing a Chapter 11?
So when somebody comes to the firm to discuss a Chapter 11, one of the first things I look for is if the company has too much debt but has a chance to move on. It usually doesn't work if there are no changes that can be made. If somebody comes in and says, hey, we have a business here, we're not doing well, but I know things are going to pick up, I know the economy is going to get better, that's generally, we'll go through it, but generally not a candidate for Chapter 11. Chapter 11 is generally if somebody has distinct problems that can be fixed so that they can move on in business. For example, if you have a company, I had one Chapter 11 debtor, was a company that just had too expensive a lease, a property lease, the real estate lease. And it was clear that if we could get them out of that lease, which you can do in Chapter 11 under certain circumstances, if we could get them out of that lease into better space, more affordable space, that moving forward, they wouldn't be able to pay their creditors in full, which is part of a Chapter 11, is being able to pay them less than in full, but they could stay on in business.
So that's the kind of help that they can get from Chapter 11?
Yes, yeah, they can reduce their unsecured debt. A typical plan might be where a company has $200,000-300,000 in what we call unsecured debt, generally trade debt, and that can be reduced in the plan, sometimes to 20, 25 cents on the dollar, paid out over a few years. It's also possible to cram down secured debt, and I use the term cram down because that is an actual term of art. When it comes from the notion of cramming it down the throat of the secured creditor. You can stretch out tax debt, like I said, get rid of burdensome leases. So you can do all these things. It's actually a great tool for a company that can otherwise succeed moving on.
Well, I think that's important in that business people go to a bankruptcy lawyer that specializes or concentrates their practice on Chapter 11 because there's a lot of nuances I don't think you're aware of. What are some of the common mistakes then that things that, when things get tough, what are some of the common mistakes people make?
So one of the more troubling things that I see when somebody comes in is that business owners are not necessarily, before they open their business, schooled in how to operate their business and who they should pay and who they shouldn't pay when things get tough. And probably the most common mistake we see is that businesses use the IRS and the Department of Revenue as a bank, essentially, as a lender. And what I mean by that is that they will withhold
Paying taxes?
they'll withhold their taxes
Yeah.
from the employees, or if it's sales taxes, these are all called trust fund taxes. They're supposed to withhold them and pay them over to the IRS or to the DOR, depending on what it is. And what businesses often do is they withhold them from paychecks, withhold them from, if it's a sales tax issue, and don't pay them over. So the next thing you know, they build and you owe taxes, and these are taxes that don't go away.
Because they're secured, right?
They're called trust fund taxes,
Okay.
and it's essentially, it's like a conversion. It's like you're stealing the money essentially, because you've taken it from
someone to pay
employees
the
or
tax.
to pay the taxes, and you haven't paid it. So if things get really bad, and if the company or the owner winds up in Chapter 7 because of their problems, those taxes don't go away. And I deal with those very often, and there's really very little solution.
Now, can we kind of go over what the plan would be on a Chapter 11? Like, what would you do first? Once someone comes into you and basically says that this, and you decide that this is probably what's going to happen, can you kind of go through the plan with us on what you would do next?
Sure. When somebody the plan itself in a Chapter 11 generally doesn't happen until at least 3 or 4 months into the process. There's what's called an exclusive period under Chapter 11, where the debtor is the only entity or person who can file a plan. And that 120-day period is usually used to get everything together and make the changes you need to make, do a budget to show how you can succeed going forward. So that happens later in the process.
So David, during that time, I'm sorry,
Sure.
is there a stay then from the creditors at that time?
Yes.
Or, okay.
Like as with your Chapter 7 and Chapter 13, Chapter 11 creates an automatic stay under the Bankruptcy Code. It's the same section of the code that regulates the stay. So that means whoever is suing you, because generally when somebody comes in, they're being sued or they're facing a foreclosure. So that means the foreclosure stops, the lawsuits stop, the dunning stops, and there is eviction stops. Everything stops, and there's a cooling off period. Now, under certain circumstances, a creditor can move for relief from the automatic stay, and if they can show why they're allowed relief, meaning the ability to go ahead and proceed with whatever it is they were doing, the foreclosure, the eviction, whatever it was, then the court will grant that. But that's awful tough in a Chapter 11.
Do they have to show a hardship or something?
They have to show, well, there's a whole series of things that they have to show, but generally they have to show that if, for example, it's real estate they're trying to foreclose, they have to show that there's no equity in the real estate. They have to show that there is, they have to show that the real estate isn't necessary for reorganization. It's a pretty tough burden. The courts in Massachusetts especially can be debtor friendly and understand that the bankruptcy process is there to give a little cooling off period to the debtor so they can try and work things out. So generally, a creditor who comes in and tries to get this relief early on doesn't do it.
So now after this like 3-month period of time, what would then be the next part of the process?
So after the 3 months, and after you've taken several steps to get things back in order, you file what's called a plan and disclosure statement. And the plan, it's a little bit different than the Chapter 13 plan that you talked about previously. It's first of all, it usually involves a lot more. In Chapter 13, there's no disclosure statement. The disclosure statement is like it's like a public offering memorandum for anybody who buys stock, and although in smaller cases it doesn't look quite as complicated, but it's supposed to be a layman's expression of what the plan is going to be. You're not supposed to have legalese in there. It's just supposed to describe what's going on. And so the disclosure statement describes the history of the company, what got the company into trouble, what the company's been doing the last several months to fix itself, and then describes the plan. And so the disclosure statement is filed with the court with a copy of the plan, and a hearing is generally set 30 days after the disclosure statement is filed. There's no voting or anything on the disclosure statement. That's just a chance for everybody to weigh in and make sure the disclosure statement contains what it should and it follows the rules. And once that's done, then the disclosure statement goes out to all creditors along with the plan for voting. And then, unlike Chapter 13, creditors have to vote on the plan. And that's
okay.
That is the big gating issue in Chapter 11. Can you get the creditors to vote in favor of the plan? And in order to succeed with your plan, first, as I said, you have to show that the creditors vote in favor of it. And the way they vote in favor of it is there are different creditor classes. So typical business, let's say the business has a lender, a secured lender who has a lien on all the assets, and then it has some tax debt, and then it has a couple $100,000 of unsecured debt. The lender gets a vote in its class, and that's one separate class. The tax debt is a separate class. They don't vote. The taxing authorities don't vote as long as you treat them in accordance with the way they should be under the plan. And then the third group is the unsecured creditors, and they vote as a class. And in order to confirm a plan, you either have to have every class, in our example we have 3 classes, you either have to have every class vote in favor, or you have to have one class vote in favor, and the plan has to be fair and reasonable to the other classes. And that's where the fight usually comes in.
Yeah, I was going to say, I can see why this can be difficult.
It can be. The way you get approval, let's say in our example, you have $200,000 worth of creditors, unsecured creditors, and let's say there are 20 of them that make up the unsecured debt, or 21 of them to make it a little easier. I'm not very good in math. So in order to succeed, you have to have half in number of the creditors. So say 21 vote, you need to get 11 votes. And those 11 have to control 2/3 of the total dollar amount of the debt. So whatever 2/3 of $200,000 is. And if you get that, sometimes your plan can be approved if it's otherwise fair and reasonable to the other creditors. And it's also feasible. You have to demonstrate through a budget. You need an accountant too, by the way. If you in addition to having a good lawyer who will do Chapter 11, you need a good accountant who can help with a budget and to show that this plan is feasible, that what you're proposing to do for your creditors is feasible. The business is going to succeed, essentially.
Now, getting them to vote, is getting the secured creditors versus the unsecured, which are the more difficult group to get to vote in favor of it?
It depends what you're doing. Generally, each secured creditor is a separate class, so you only need one. You're only trying to get one vote from the secured creditor. But a lot of times, these Chapter 11s, what we're trying to do is change. We're there because the secured creditor wanted to take the assets from the business. They wanted to shut down the business. So what we're doing is we're essentially forcing, as I said, a cram down. You're forcing the secured creditor to make a change in the debt. You know, if there's $1 million line of credit that's now come due, there is a way to take that $1 million and stretch it out over time, reduce the interest rate, if you can demonstrate that it's fair and reasonable. So you're not going to get the vote of the secured creditor in that case. You're going to get, so you need the unsecured creditors. And that's what you have to weigh. You have, you're going to give the unsecureds enough money to vote in favor. And the other thing is, one of the bigger issues for unsecured creditors, and what you try to explain is, look, business is tough enough, right? And finding clients and customers is tough enough. So if we go out of business, you're losing a client or a customer. So yeah, you took a hit, but help us stay in business, help us reorganize, and you'll have a client still. And you'll keep us on tighter credit terms, we understand. You might even be COD for a while, but keep us in business. And that's usually how you can sell a plan like that.
So what's the process after the voting and you get the go-ahead that the plan is okay? What happens next?
That's basically toward the end of the process.
Okay.
So once the plan is confirmed, once you go to court and you show the court that we have the votes, we have the feasibility, it's fair and reasonable to everybody.
Is that when you go in front of the trustee after that, or?
There is no trustee.
Oh,
in Chapter 11, there's no trustee. Okay. Well, there can be, but in general, there's no trustee. The only time you have a trustee in Chapter 11 is if there's been misconduct, if the court, for some reason, believes that the debtor and the debtor's principal is incapable of operating, and so then the court will either convert the case to Chapter 7, in which case a trustee is appointed, or will appoint a Chapter 11 trustee. That's fairly uncommon.
Now, you and I were having a discussion prior to airing the show about the fact that sometimes small businesses can use Chapter 7. Do you want to talk about that at all?
Sure, yeah, I'd love to, because this is something that I've been trying to press with people more, other attorneys, and trying to make this more of a viable option. And the reason for that is everything we've talked about so far, it's expensive. It gets expensive. Like I said, you need a good lawyer and you need a good accountant, and there are other fees and involved in filing a Chapter 11. You have to pay the government. It gets expensive. I would estimate that even for a small business, filing a Chapter 11 could cost you, $30,000, $40,000, $50,000 in the end. So in my mind, it is possible to use a Chapter 7, even though Chapter 7 is a liquidation, it is possible to use a Chapter 7 to essentially keep your business running. And what I mean, and that, first of all, that's a much less expensive option. You can file a Chapter 7 for under $5,000. The problem with a Chapter 7 is you lose control of your business because, as I said, a trustee is immediately appointed. And generally, in a Chapter 7, the business ceases to operate the minute you file. However, there are provisions in Chapter 7 in the Bankruptcy Code that allow a trustee to continue to operate the business if it's going to benefit the creditors. If by keeping it as a going concern, the creditors stand to make more money. So I've had situations where clearly the company can't afford to file a Chapter 11, but in a way, the company could file a Chapter 7. You generally have to set this up in advance. You have to have a buyer, and you have to be ready to go to the trustee immediately and say, look, here's what we got. We have a buyer, we have a management agreement in place, we have a continuing business, and if you don't do it, Mr. Trustee or Mrs. Trustee, there's going to be nothing for creditors. But if you operate for a short period of time, then we can get the thing sold, get the business sold, and creditors will make some money. There will be like I said before, creditors want to see continuing customers and clients, and so let's do this, and you can get it done. And we've done it a few times with businesses. The key is to be able to try and keep it running, and just for long enough to get it into somebody else's hands.
Now, is there a way under Chapter 11, like can you reorganize without filing under Chapter 11?
You can, like with a Chapter 7, or you can do it without filing anything. There are problems, though, with that generally. One of the ways to do it is what we call an assignment for the benefit of creditors. That is basically an out-of-court state law bankruptcy, even though it's not really a bankruptcy. Mm-hmm. It's a reorganization or liquidation, if that's the right circumstance. What happens with we call it an ABC, is that you essentially hire your own trustee. You hire an assignee, and so you have more control over the situation, and you work with the assignee to get creditors paid. Maybe sell the business again like you would in a Chapter 7 and keep it as a going concern for a while. So that's one way. Sometimes, what people will just try and do is just reopen under a different name. That's a problem. I had somebody.
Does that happen a lot in real estate? It seems that sometimes builders do that.
They do. Yeah. They do. And the problem with that is a doctrine in law. It's a state law doctrine called successor liability. And what that means is, so you shut down your business. Let's stick with your contractor. You're a contractor, you shut down ABC contracting and you open, DEF contracting. And the next thing you know, you're doing the same thing as you were doing last week. You have the same employees, the same customers, but you're just doing it under a different name. Creditors don't really, they're more savvy than that. And what they will do is they will often sue the new company saying you're the same as the old. You're a successor or a mere continuation, or the words like de facto merger come into play. And so those generally don't work because it doesn't get you what you need. And the other problem with that is almost always there's tax debt involved, and almost always it's these trust fund taxes, and it doesn't help you walk away from that. So at least with the bankruptcy, Chapter 11 especially, you can take the trust fund taxes or income taxes or whatever they are, and you can stretch them out over 5 years, 5 years from the date you filed. Okay. And that's pretty helpful. You still have to pay interest, but you don't have to pay penalties, but you can stretch them out. And so that's generally why an out-of-court or just some sort of reorganization without some sort of bankruptcy can be tough. But they do it.
Now, we talked about cases where it wouldn't work, reorganizing, just doing the same thing in a different name. Can you talk about some successful cases that you've had with Chapter 11? Sure.
We've had a lot of success, fortunately. There are successes that you hear about on TV, like hopefully American Airlines will be a success, and it takes a long time. And what ends up happening is, in that case, for example, hopefully there'll be a sale to US Air, and the airline will continue to operate. In my smaller world, we have a good amount of success as well. For example, we had a printing company a couple of years ago, and the printing company was doing fine, but it had 5 or 6 of these huge printing machines that were outdated but still worked. But they were paying a huge amount. They leased them, and they were paying giant lease payments. They were paying about $15,000 a month. So, and that was just killing them. So what we ended up doing was we did something called rejected the leases. In the Chapter 11, you can either assume the lease, which means, yes, I'm going to keep it and keep paying it, or you can reject it. And you say, no, I don't want it anymore. Come take your equipment. I don't want the lease. And then whatever's due on the lease becomes one of those unsecured claims that we were talking about. So when you do that, we have these huge pieces of equipment. The equipment lessor says, I don't want to come get them. They're not worth anything because they're old. It's going to cost more to move them than to leave them there. You want to buy them. And we did in that case. We bought all of those pieces of equipment that were leased for $15,000 a month. We bought for $15,000. So that right there was
helped the company.
That was the gating issue that we needed. That alone allowed the company to restructure because it was just running a deficit every month because of those leases. We've had restaurant cases that are successes. Restaurants can be difficult for a lot of reasons. One of them is...
I've always heard the food industry is just really difficult.
Yeah, I mean, it's a tough business anyway. If you're somebody who opens a restaurant, I got to give you a lot of credit because it's tough just on a day-to-day basis. You got to be there all the time, and it's just tough, competition-wise. But in bankruptcy, they present some difficult problems. One of them is, when you're a restaurant owner, you're there 24/7 running the restaurant, and you may be a restaurant person but not a numbers person, for example, and so you really need a numbers person to succeed, and you need to be able to get those numbers turned around. And for some reason, it just seems difficult in restaurant cases, but we've had successes. Same thing, maybe it's the lease the space that they're leasing, yeah. And sometimes landlords will be when they understand, when you go to a landlord beforehand and you say, look, we can't make rent, you got to give us a reduction. Landlords are disinclined to do that. But once you're in bankruptcy and the landlord knows that there's going to be a vacant space, and it may be a year or two before they're going to fill that space, then sometimes you get a little more traction. So things like that, sometimes work.
Now, are there any preferential transfers, like priority, can people, secured creditors are probably priority over the unsecured creditors. Can you kind of explain to the community what that means to have a preference? Or?
Sure. The preferential transfers are a real problem for vendors because it's only understandable in the bankruptcy world. A preferential transfer is a transfer that a debtor makes within the 90 days prior to the filing of the bankruptcy. The period goes back 1 year if it's insiders, if you give money back to your uncle or something like that. But for regular vendors, it's 90 days, and what ends up happening is I have a case I'm working on now, for example, where it was a big case. It was a Chapter 11 that was filed in Boston, and it was a women's apparel company. And the Chapter 11 plan was confirmed. I didn't work on the case. The Chapter 11 plan was confirmed, and as part of the process, the liquidating trustee who was appointed in the case, in this case it had a trustee, you were asking about it earlier, yes. This case had a trustee. The liquidating trustee then went out and sued about 70 vendors to recover preferences. And so when a vendor gets a letter, it says, hey, we're suing you for $20,000. And almost in each instance, the vendor is actually owed money by the debtor, doesn't think he owes money. And the vendor says, how is it that I have to give money back to this company when they owe me a fortune? And it's sort of doesn't make sense, mm-hmm. and I understand that, but the goal of the bankruptcy code is to treat all creditors equally. So the concept, it doesn't always work this way, but the concept is you bring in the payments that came for the last 90 days that were preferential, meaning that some people got paid and some people didn't, and then you redistribute it equally. Usually it goes to the expenses of the Chapter 11, but people get those letters, and that's why I wanted to talk about it today, is because that, nobody understands when they get them, which is I understand, because again, it doesn't make sense. But there are defenses to preferences. And so when you get that letter that says, hey, you owe us $30,000, first of all, almost always you don't. There's usually some sort of defense. There's a defense called the ordinary course of business defense. There's a defense called the new value defense. I won't get too into them, but sure. But there are ways to minimize that or eliminate it. And also, you can usually settle the case. The trustees are just usually looking to get faster money trustees, including me, by the way. I'm not, I bring them sometimes as well, but you can generally settle it. So if you're a small business owner and you get one of those letters, after you're done screaming and yelling, call an attorney, and there are ways to address it.
Now, is that true in Chapter 7 as well? Like if a secured creditor holds an auction prior to someone filing, could they basically have to, any monies that they brought in from the auction?
The preferences, first of all, yes, Chapter 7s, there are preferences in Chapter 7. The Chapter 7 trustee will try to recover preferences. One of the elements of a preference, one of the things that has to be proved by the trustee, is that the creditor would get less in a Chapter 7 than it would have by getting paid. So a secured creditor who holds an auction, is generally not a preference, because the secured creditor has collateral, and so what they get from their collateral they would have gotten in a bankruptcy. There are exceptions to that. For example,
there's always exceptions.
Yeah, there are. That's what keeps us busy, right? One of the things that's happening lately, it's a little off topic, but I think people will be interested in it, and I don't know if you covered it in your Chapter 7 case. But one of the things that's happened lately is trustees are looking more at mortgages and security agreements to see if they are what's called validly perfected. And you and I know from law school that valid perfection in the case of a mortgage requires that everything be done perfectly and that it be recorded in the right way at the Registry of Deeds. Well, with all the mortgages in the last 10 years and everybody rushing to refinance and banks giving mortgages to anybody who asked for them, a lot of the work was sloppy. And what happened in certain circumstances, for example, was you might go to your closing and sign your closing documents, and the notary might forget to put your name on the notary jurat, for example, or might say the wrong thing in the notary, or might get confused. And so what's been happening lately is trustees have been challenging the secured creditors, the perfection of the secured creditors' lien in bankruptcy, which they can't, once a bankruptcy is filed, they can't go back and fix. So secured creditors like banks have been in trouble because, here they are, they think they have a valid $300,000 mortgage on your business property or your home, and they really don't. And the trustee can sell the property, or the debtor in the Chapter 11 can treat you as an unsecured creditor. And that's a good bonus for debtors and trustees. It's not so good for the banks.
Oh, that's interesting.
Yeah.
Well, do you have anything you want to finish or a conclusion before we end this topic?
Not really. I guess to say that Chapter 11 is a good tool even for small businesses, if you can afford it, to reorganize. Or, as I said, a Chapter 7 can be used for that purpose. But if your business is starting to do poorly, try to avoid the mistakes we've talked about today.
Yes.
Pay the taxes, because those just are not going away. Pay your employees, because that's a crime not to pay your employees. Don't borrow money from your employees. That's a crime as well. If you're starting to feel the pressure, come see somebody. See me, or so there are others. There aren't too many people out in the suburbs who do Chapter 11s, but there are other lawyers as well, and other good ones. And just get some help. Generally we offer a little bit of free advice, and come in and get some advice and see if you're a candidate for one of these things, or if there's some other ways to turn around your business.
Are you a trustee as well?
I am. I'm a Chapter 7 panel trustee. I serve the southern part of the state, which is Bristol County, Plymouth County, and the Cape and Islands. So that's a good part of my work.
So this area would mostly go to Boston?
Medfield goes to Boston. Medfield's Norfolk County, goes to Boston. Then if you're further out towards, I forget where the line is, and some of the Middlesex County towns go to Worcester, and some go to Boston.
Okay. Okay.
So,
Well, thank you, David. This was very informative, and we really appreciate you coming in to go over that with us today.
well, thanks for having me. I enjoyed it.
Well, that ends our series on bankruptcy. Next month, I will be discussing different ways of doing alternative dispute resolution. We will have another attorney coming in to talk to us about arbitration, mediation, and I'm a trained conciliator, so we'll also be talking about conciliation. So thank you for joining us today.
Production support provided by Medfield.tv. Access to our community.